Morning, everyone. I'm Trey Zanudo. I'm the Vice Panels Chair for this year's symposium. Thank you for being here bright and early in the morning after what I imagine for most of you was a real late night. But this morning's panel is titled Congress and the Constitution, the Separation of Powers in Action. In recent years, Congress has increasingly turned to a range of procedural tools and ideas to assert its role within the separation of powers framework established by the Constitution. These mechanisms allow Congress to navigate and counterbalance the authority of administrative agencies, reflecting its constitutionally granted powers to legislate, oversee, and hold the executive accountable. Considering the opportunities and challenges arising from such engagement, this panel will examine whether Congress should pursue a more active role in day-to-day enactment and oversight of laws. Moderating this panel is the Honorable Judge Robert Luck of the 11th Circuit in the great state of Florida. Judge Luck earned his JD from the University of Florida's Frederick G. Levin College of Law. Afterward, he clerked for the Honorable Judge Edward Earl Carnes of the 11th Circuit. Prior to his current role, Judge Luck served as an AUSA for the Southern District of Florida and as judge on the 11th Judicial Circuit of Florida, the 3rd District Court of Appeal in Miami, and the Florida Supreme Court. Relevant to his expertise on the subject, Judge Luck was earlier in his career a legislative correspondent for 2 United States senators. Our esteemed panelists are Josh Chafetz, Professor of Law and Politics at Georgetown Law. Josh Chafetz received his doctorate in politics from Oxford, where he studied as a Rhodes Scholar, and his JD from Yale Law School. Following law school, he clerked for Judge Guido Calabresi of the 2nd Circuit. His research interests include structural constitutional law, American and British constitutional history, legislation and legislative procedure, American political development, and the intersection of law and politics. His second book, Congress's Constitution, Legislative Authority and the Separation of Powers, inspired this panel. Gillian Metzger, Harlan Fiske Stone Professor of Constitutional Law at Columbia Law School. Gillian Metzger received her JD from Columbia Law School. She clerked for U.S. Supreme Court Justice Ruth Bader Ginsburg and Judge Patricia M. Wald of the D.C. Circuit. A leading administrative and constitutional law scholar, Gillian Metzger writes and teaches in the areas of administrative law, constitutional law, and federal courts, with an emphasis on federalism and privatization. Metzger's recent work covers topics ranging from constitutional attacks on the administrative state to appropriations, administrative law under the Roberts Court, and the role of administrative agencies in a polarized world. Jonathan Adler is the Johan Verheij Memorial Professor of Law and the founding director of the Coleman P. Burke Center for Environmental Law at Case Western University School of Law. Jonathan Adler received his JD from George Mason University School of Law. Professor Adler clerked for the Honorable David B. Santel on the D.C. Circuit. He teaches environmental, administrative, and constitutional law courses and has testified before Congress 12 times. Amanda Neely is of counsel in the Washington, D.C. office of Gibson, Dunn, and Crutcher, and is a member of the Public Policy, Congressional Investigations, White Collar, and National Security Practice Groups. Amanda Neely earned her JD from Duke University School of Law. Ms. Neely clerked for the Honorable David B. Santel on the D.C. Circuit. Ms. Neely held several senior staff positions in Congress. She served as Director of Governmental Affairs for the Senate Homeland Security and Governmental Affairs Committee and General Counsel to Senator Rob Portman. Under Senator Portman's chairmanship, she also served as Deputy Chief Counsel for the Permanent Subcommittee on Investigations. And the Honorable Justin Amash, who represented Michigan's 3rd Congressional District in the U.S. House of Representatives from 2011 to 2021. A double Wolverine, Justin Amash earned his BA and JD from the University of Michigan. During his time in Congress, Mr. Amash earned a reputation as an independent thinker who closely embraced the principles of the Constitution. While here at Michigan Law, Justin Amash was a favorite student of Professor Richard Primus. Again, thank you for being here. There will be Q&A at the end of the panel, so please keep your questions in mind. And I'll now pass the floor to the Honorable Judge Luck. Thank you.
Trey, thank you so much for that warm introduction. Thank you. Thank you so much for that warm introduction, Trey. We appreciate it. I think I can speak, I'm sure I can speak on behalf of my co-panelists in saying how honored we are to be here this morning, having the panel with everybody here. Any symposium on the role of Congress in our system of government must begin, it must, with a discussion of the powers that Congress actually has under our Constitution. So that's what we are going to do this morning. Professor Chafetz, who literally wrote the book on Congress's Constitution, will give us an overview on the tools that Congress has at its disposal in the struggle between the branches of government. Professor Metzger, Professor Adler, and Ms. Neely will discuss 3 of those tools: the appropriations power, reauthorization, and investigations. And then finally, you're going to hear from former Congressman and Michigan law alum, Justin Amash, who will discuss how each of these tools are in fact used or not used in practice. Now, we're going to do a little bit different than you see at normal panels. We're going to structure it a little bit differently. What we're going to do is, after a panelist does their talk for about 5 or 7 minutes, we're then going to have a full discussion about what the panelists talked about before we move on to someone else. So instead of serially going remarks, we're going to do discussion after each remarks. I think that way the hope is that we have a really great and dynamic back and forth, which we're going to try to do, and I'm going to try to facilitate. And then at the end, we're really looking forward to having questions from everybody here. So with that, Professor Chafetz.
Thank you so much, Judge Luck. Thank you to Trey and to all the organizers. This has been a beautifully run conference so far, and I really appreciate all of your hard work and also being able to be here with you all today. I especially appreciate it because FedSoc has a sort of long and glorious history of really caring about congressional power. I've done work with FedSoc's Article 1 project before, and I think this is a sort of really important component of the work that the Federalist Society has done, and I'm very pleased to be able to be here and speak to you about it today. As both Trey and Judge Luck mentioned, my own sort of largest contribution to this field is a book I wrote a few years ago called Congress's Constitution, which is largely about the sort of tools that are available to Congress in interbranch conflict. Primarily conflict with the executive branch, but conflict with the judiciary as well. And part of the sort of core premise of that book is that sort of statutory restrictions, things on the order of the War Powers Act or the Ethics in Government Act, are relatively unavailing, right? They're likely to be passed only in sort of extreme times, right? Both of those were passed in the aftermath of Watergate. And in normal times, right, if the president doesn't like restraints on his or her power, which is likely to be the case, then the president can veto those. If the judiciary doesn't like restraints on its power, it can either strike them down or interpret them into oblivion. And so those kinds of direct legislative attacks on the power of the other branches are likely to be relatively unavailing. So what does that leave Congress with? And my argument in the book is that it does leave Congress with a relatively potent toolbox. So I'm just going to mention a number of the powers that I talk about in the book sort of very briefly. As Judge Luck mentioned, my colleagues on the panel are going to go into several of them in greater detail. But first, and I think perhaps most importantly, primus inter pares, is the power of the purse, right? Both the taxing and the spending power, the idea that the legislature is the principal and first mover in levying taxes, right? Taxes cannot be levied except by congressional approval, but also in spending decisions, right? That money cannot be spent without congressional approval, but also that when Congress demands that money be spent, that money has to be spent, right? This is a power that was heavily fought for in 17th century England. It was sort of at the core of the struggles between the Crown and Parliament, and it was at the core of what the 18th century American colonists and founders sort of thought they were doing when they created legislatures. And I'm certainly happy to talk more about the history of any of these powers as we go forward. The second major power I talk about is what I call the personnel power. So this is obviously the Senate's role in confirming nominees. It's both chambers' role in the impeachment proceedings. And it's also, more generally, both chambers' roles in when they're drafting organic statutes, the choices they make about structuring agencies, right? How many officers, how many employees are going to be in any given agency, what their job descriptions are going to be, how much tenure protection or not they're going to have, right? Those are all sort of personnel-based choices that Congress can use and that it can use in various ways to sort of limit or to empower the other branches. Third is the power of oversight and the sort of concomitant power of contempt of Congress, right? So the ability to gather information from and about the other branches. But also to use those, as I talked about more in a subsequent work, a law review article called Congressional Overspeech, to use the information gathered as a way of making a public case, right? Not simply passively receiving information, but actually structuring hearings so as to make a case sort of to the public in a way that may or may not be congenial, right, to the other branches. Relatedly, a sort of fourth important power comes from the speech or debate clause. The fact that members of Congress can, even as sort of individual members, right, can take to the floor and can disseminate information that the other branches may really not want disseminated, right? So in this vein, I think about the fact that Senator Mike Gravel read the Pentagon Papers into a subcommittee record in the 70s. I think about the fact that Senators Wyden, Udall, and Rockefeller informed the public in floor speeches about secret OLC interpretations of the Patriot Act in the early 2000s. And then finally, and perhaps least obviously, but the Rules of Proceedings Clause, right? The Constitution's power, the Chamber's power to determine their own rules. These can be used in ways that build capacity, and it can be used in ways that destroy capacity. But from the sort of earliest days of sort of partisan conflict in the mid-1790s, right, when Albert Gallatin creates the Ways and Means Committee in the House of Representatives, the chambers have used their power, and Gallatin, by the way, is sort of explicitly creating that committee as a pushback against Hamilton's Treasury Department, right? The chambers have sort of used their power over their own internal proceedings and their own internal structures as a way of asserting themselves against the other branches. So that is like the very, very quick overview of the congressional toolbox. But I want to sort of note that at the end of the day, the efficacy of those tools really depend on and I should say, I didn't say this in the book because it didn't occur to me that I would need to say this in the book. It was not front of mind, but it really depends on a baseline assumption that the other branches, and most especially the executive branch, will make at the very least a good faith effort at law compliance. Right? At the end of the day, the executive branch is the one with all of the guns. It's the one that has way more personnel than any of the other branches. And so if it simply decides to opt out of law compliance, there's absolutely nothing that any of these tools can do. Right? Congress can cut off funding, but if the executive branch says, I don't really care about the appropriations clause of the Constitution, I'm going to break into the Treasury and take what I want, there's not a whole lot that Congress as an institution can do about that at the end of the day. And I think it's important to say that at this moment, and in a room full of people who are sort of interested in congressional power and devoted to the proposition that Congress does have a rightful place in the constitutional order, because I think it is fair to say that we are currently facing an existential threat to congressional power and through it to our constitutional order itself. In the last month and a half, right, we have seen an administration that claims that notwithstanding the clear text of appropriation statutes, that it has the right to impound funds without making even the pretense of a compliance with the Impoundment Control Act. Now, this may sound sort of minor and technical, and Professor Metzger is going to talk, I think, more about impoundment in a minute. But the point I want to make here is simply that what impoundment actually is a claim that the executive doesn't have to comply with statutory law, right? Appropriation statutes are statutes, right? They are law. And for the executive to say, we don't have to spend money that has been appropriated in a mandatory fashion is simply to say, we get to choose when we will comply with statutory law and when we won't. That's a power that the 17th century Stuart monarchs referred to as the dispensing power. They were, as many of you know, forcibly driven from office not once but twice over the course of that century. And indeed, the first two provisions of the 1689 Bill of Rights after the Glorious Revolution are dedicated to denying what it calls the pretended power of suspending or dispensing with the laws. Right? And yet that is the claim that the current administrator of the Office of Management and Budget has made, that the president has an inherent right to do that. This administration has also ignored the clear language of appropriations riders, denying it the power to do certain things. It has destroyed agencies that have been created by statute, despite the fact that there is no statutory authorization for the destruction of those agencies. It has dismissed officers who have statutory tenure protections, and it's fired employees, notwithstanding civil service protections. Just yesterday, it announced that it was withholding hundreds of millions of dollars from a university because it dislikes that university's policies, despite the fact that that withholding is not consistent with either the procedural or the substantive provisions of the applicable law. And just yesterday, we found out that the administration believes that it has the authority to not only fire the head of an agency that has tenure protection, but then to appoint an acting head of that agency, notwithstanding the fact that the Federal Vacancies Reform Act explicitly exempts that agency from having an acting director. In other words, the claim is that there is an inherent Article II authority to appoint someone to that office, despite a statutory denial of authority to appoint someone to that office. These are not, I think, cases where sort of reasonable, legally informed people can disagree. These are situations in which the executive is claiming an inherent authority to opt out of the law. These are, I think, consistent with the actions of a president who, within the span of a week, compared himself to Napoleon and declared that he is the king, and whose official White House social media accounts, not his personal accounts, but official White House accounts, then posted a picture, an AI-generated picture of him wearing a crown and royal regalia. The sort of thing that when it was suggested to George Washington that he become a king, he responded angrily, not only that he would not do so, but that the very suggestion was offensive and inappropriate in a republic. So, I want to sort of suggest to all of you, especially because people in this room are the kind of people who sort of are going to be key players in what happens over the next 4 years, that if the commitment to congressional power, if the commitment to Congress having and exercising the tools of its office is one that you genuinely and deeply hold, then there need to be responses to this kind of action. And those responses largely, it would be great if more of those responses came from members of Congress, but the responses need to be broader than just coming from Congress, because these actions that I've described to you are, each and every one of them, end runs around congressional power, and end runs that have been justified not even by spurious claims of legality, but simply by the claim, I can do what I want. Thank you.
Thank you, Professor Chafetz. I'll start by ending there. I'll start our discussion by ending where you ended, which is how has, and I know it's only been 6 or 7 weeks, the second Trump administration's actions with respect to congressional power, some of the things you just talked about so far, differed from or similar to previous administrations? I know there was critique of how other administrations handled certain acts that had not been authorized by Congress. The Supreme Court specifically has specifically said that certain actions were outside the authority given to certain administrations. Is this just a matter of degree? How is this substantively different or similar to things that have happened with other administrations? And then I'll open up to other panel members to comment.
Right, so that's a great question, and it's very clear, right? Administrations of both parties going back decades, if not centuries, right, have pushed the bounds of executive authority, right? That is not in and of itself new in any way. I think there comes a point where a difference of degree becomes a difference in kind. So I think there's sort of two broad ways I want to answer that, right? One is, I think the kinds of claims being pushed by this administration are in many cases substantively different, which is to say they are not making sort of plausible good faith efforts to provide legal justifications or to claim compliance with the law, right? They are simply bulldozing ahead and sort of doing what they want and letting the sort of legal chips fall where they may, right? They're not putting forth sort of plausible legal arguments, even if those legal arguments later turn out to be wrong. And then the second is just the sheer scope of it, right? The sheer sort of amount that has been done ultra vires over the last, whatever it's been now, 6 or 8 weeks, I think dwarfs anything that we've seen out of any other administration. And so I think it is the case that, for any individual thing, well, I shouldn't even say that, for many of the individual things, you can find facially similar examples in previous administrations. Now, I think that's not necessarily the case with impoundment. Every president since Nixon has at least claimed to comply with the Empowerment Control Act, right? I think there have been sort of precious few situations since Nixon where presidents have plausibly not complied with the Empowerment Control Act. But in many of the other situations, I think you can find sort of individual acts from previous administrations of both parties that look facially similar. But I think the real issue is the sort of aggregative one, right? The fact that while any individual act may have plausible precedent, the sort of overwhelming onslaught of it, the sum total here is sort of different enough as to make it, I think, a difference in kind and not simply in degree.
And that's where I'd like the other panel members to weigh in. Is there agreement on that or any disagreement regarding whether, so the two things that I think Professor Chafetz pointed out is no plausible legal arguments in support of the actions of the current administration and that the scope is somehow different and making it different in kind as opposed to degree. Professor Adler, I see you wanting to weigh in.
I do disagree. I mean, certainly in terms of scope and volume, I fully agree with Professor Chafetz. But in terms of have we, in the last several administrations, seen administrations take actions first and then try and cobble together a legal justification afterwards? Absolutely. Have we seen administrations take actions with no consideration whatsoever of the legality until after the action is taken and then try and come up with answers after the fact? Absolutely. Have we seen administrations make arguments that no one who really looked at the underlying legal issues thought were good faith arguments? I mean, we could just, for example, look at the Obama administration's implementation of the Affordable Care Act, waiving away the employer mandate penalty, the so-called if you want like your doctor, you can keep it fixed. This is stuff that I've written about. Professor Bagley's written extensively about this. A lot of these were not good faith actions. They were actions that were taken because the administration felt in order to achieve its policy objectives, it had to take them. In the case of the employer mandate penalty, we know that the IRS did not think about the legal justification until after it did it. We also, for example, in the Biden administration, we can argue whether there was a good faith argument for example, for the student loan withdrawal, but there was no good faith argument to, after announcing it, to then gerrymander the contours of the program kind of midstream with the sole purpose of denying anyone Article III standing to be able to sue. Now, at the time, during both the Obama administration and the Biden administration, I was one of folks that was saying, people need to call this out because there will be an administration that will be more brazen and will do these sorts of things with less pretense about trying to conform with the law. And that is, in fact, what we are seeing now. Because I would agree the current administration is more brazen. There is less pretense of compliance. And instead of doing it here and there, is doing it across the board. But we certainly saw that this was coming and could come. And I think the other important difference between this administration and prior administrations is there's significant pushback across the ideological spectrum, which, especially during the Obama administration, but also certainly true for many things in the Biden administration, there was a surprising lack of cross-ideological public pushback. And I think that's a problem. There's not as much cross-ideological pushback now as I would like, but there's certainly a lot more than there was during some of the prior examples that I think created some very problematic precedents that an administration as aggressive as the current one is doing its best to take advantage of along every margin.
Is there anyone else so Professor Metzger, in terms of degree or kind, what are we seeing? How is this just different in kind, or is this just another step along the imperial presidency?
I mean, I do think that it's hard to underestimate the effect of the wide array of just flood the zone and flood the zone with actions that some may just push the envelope, some are really in the face of a governing statute, and the whole point is to have that statute be challenged. And it's fine. I mean, it's fine. If you're going to, for example, remove somebody who has independence and has removal protection, and you want to tee up the issue of Humphrey's executor, I think where the court is right now, it's actually legitimate to tee that up at some point. But you do it in one case, you see what happens, rather than you fire people from across the board, a whole bunch all at once, which is just an effort then to also stymie these agencies from being able to function. The idea of, for example, sending people home or administrative leave so that agencies can't actually function. I mean, these are new things. That's not the kind of thing we've seen before, and we also haven't seen it on the kind of scope that we're seeing it now. And I think those are different. I mean, I think for sure you can come up with examples from all of the recent administrations which are aggressive pushing of the executive power envelope. That is the theme, and that is certainly a phenomenon. I do think this feels to me different. Whether it, where it ends, and part of the problem is it's just the first few weeks, so we don't know where it's going to end up and whether or not, this is an initial spate and there'll be any response to the judicial pushback or not. The one thing I was going to disagree with you is I don't think there's been anywhere near enough cross ideology here, pushback, I have to say. I think that there are many reasons and dynamics for that, and I think you're right that there weren't very many Democrats who were criticizing things the Biden administration did. I'm not saying this is, that's different, but I am not seeing today what I would expect, particularly from Congress, in terms of push. I'm just not.
I would agree. I would agree on Congress, and I think that's a problem. I would say, and I think the Affordable Care Act stuff is the best example. I mean, I point to Professor Bagley's work on that because I think he was the only prominent left of center legal figure to call out the Obama administration for things that were not even arguable, and that the administration took actions and tried to cobble the legal justifications for afterwards. And so. Is there enough on the right now? No, but there are fewer right of center academics than there are left of center academics, and there are more right of center academics criticizing the Trump administration, orders of magnitude more than left of center academics criticized the Obama administration for the Affordable Care Act. And I'm not saying that's therefore it justifies it now. I'm saying is that we have to recognize that these sorts of norm violations tend to increase exponentially. Because what a new administration does is they say, there's the one example I want, but I can now use it 10 times. And so the natural course of these sorts of things is to have the increase in scale. And, we should not just be worried about what's going to happen in the rest of this administration. We should also worry about the next administration that says, okay, if Trump is doing 10 times what Obama did, what does it look like if the next administration tries to do 10 times what Trump did?
All right, I want us to get a little more specific. We've been talking in the general, and Professor Chafetz mentioned specific tools that Congress has, and we're going to analyze and dig a little deeper into 3 of those tools. You're next going to hear from Professor Metzger. She will tell us about the constitutional and statutory background to the appropriations power and why it is such a critical congressional tool, especially in the times that we're talking about right now. So, Professor Metzger.
Thank you. What I'm going to be giving you is an overview of the normal framework, and then talking to you a little bit at the end about where some of that may be changing. So appropriations are really, I think, a truly crucial mechanism of congressional control, and both over policymaking and also just control over the executive branch. They have long been understood to be Congress's bailiwick, and there's a very strong constitutional basis for that. For one, there's the spending clause of Article 1. That's reinforced by the appropriations clause of Article 1, Section 9, which provides that no money shall be drawn from the Treasury but in consequence of appropriations made by law. In addition, there are what Professor Chafetz referred to, the tax power, other provisions, the provision to coin money, other ways that it's just clear, if you look at the Constitution and these repeated reinforcing textual references, that this was a core power that was given to Congress. And there's, of course, also the history you referred to about how much control over the purse was critical to the struggles between the executive and the legislature in both British history, and then we saw it also colonially. The Supreme Court has recognized this. So they have a decision from last term, CFPB versus Community Financial Services Association, which really emphasized Congress's broad discretion to structure appropriations as it deems best, and noted in particular that you saw in early days a number of legislative bodies exercising, again, similar kind of discretion, sometimes requiring expenditures of a particular amount is something that the Supreme Court noted in that opinion. And there also have been cases where A famous one is Train versus United States, which came out of the Nixon administration, where the Supreme Court enforced statutory, a mandatory appropriation against the administration not following through on it. So this is sort of well-established background. And using that power of the purse, Congress has enacted several framework statutes to govern appropriations. Some of these go back a long time. One from 1809 is called the Purpose Act, and it requires that appropriations be spent for the purposes for which they were appropriated, unless the statute provides otherwise. Another longstanding statute is what's known as the Anti-Deficiency Act. This one dates back to shortly after the Civil War. The Anti-Deficiency Act is the reason that we have shutdowns, and it basically prohibits agency in the executive branch from spending or obligating funds above the amounts that have been appropriated. And then a third measure is the one that Professor Chafetz referred to, the Impoundment Act. It's actually the Budget and Impoundment Control Act of 1974. The Budget Act, parts of that, set out the process, or the official regular order process for drafting and enacting the federal budget. It's a process that's honored in the breach more than anything else these days, I think. But the impoundment control part is the part that restricts the president's ability to refuse to spend, and it's, of course, what's really been in the news of late. It actually imposes pretty tight controls on the president in this regard. So, in particular, the president can make, under the terms of the Impoundment Control Act, two kinds of moves: deferrals and rescissions. A deferral can be made only for certain purposes, to provide for contingencies, to achieve savings made possible through changes in requirements of greater efficiency, and specifically it's provided by law. Those are the only three grounds, and it's absolutely clear that one ground the president cannot defer spending for is because the president, as a policy matter, disagrees with spending. And in addition, the procedural limits. The president has to send a special message to Congress. He has to identify the amount, the appropriations account, the details. This is very detailed regulation of how a president can go about doing what's called a deferral. And critically, the funds also have to be released and spent within the fiscal year. In terms of a rescission, what the president can do there is propose a rescission on policy grounds. But the president has no unilateral authority to do a rescission. The rescission gets proposed, and there's 45 days in a sort of fast-track basis in which Congress has to approve it. And if Congress doesn't approve it, those funds then must go back to be obligated, right? So these are two very restrictive options in the statute for not spending funds. OMB and GAO are the agencies that oversee federal funding, and over time they have developed a third category called programmatic delays. And these are supposed to apply really only where operational factors unavoidably impede the obligation of budget authority, notwithstanding the agency's reasonable and good faith efforts to implement the program. There's been a hurricane. You can't spend the funds. The program can't go forward within the time period. You're running into a legal requirement that you just can't meet within the time period, right? That's the kind of thing that programmatic delay is supposed to be about. The other thing to focus on, these are the framework statutes, but then you have individual appropriation statutes. And some of those individual appropriation statutes do give a fair bit of discretion. They will be, you can spend up to or no more than. A lot of appropriation statutes have provisions where you can transfer funds from one appropriations account to another. You can often reprogram within an appropriations account. So there certainly is discretion there. But there are also a lot of mandatory statutes that require funding, statutes that don't leave discretion in the executive branch. And there are also, something else Professor Chafetz referred to, a number of appropriation riders in appropriation statutes, right? Things that basically, the traditional form is to say no funds are available to be used for a particular form, particular action or activity. And one that was in the news recently was the NIH rider, and it says it prohibits NIH from using any funds to develop or implement a modified approach to determining indirect cost rates on grants other than the rate provided in the Appropriations Act, right? So the agency is prohibited from using any of its funding to do this action, so it can't even suggest or propose it. So basically what you come down to is the executive branch can't spend funds on anything that the funds haven't been appropriated for by Congress, can only spend those funds that have been appropriated, and can't refuse to spend funds for purposes with which they disagree. And of course, agencies need funds to act. So these are really critical constraints and explain why appropriations are such an important congressional mechanism of control. Another key feature to bear in mind is that most appropriation measures that fund the government, not most appropriations overall, we have a large number of what are called permanent measures, think Social Security or Medicare, but most of the appropriations that fund the government are done on an annual basis. So this is actually an important mechanism of ongoing control, right? This is a way that Congress can, under this model, wield control over what agencies are doing. And another thing that plays in here is the must-pass nature of appropriations, right? If you don't get that appropriations bill through, you need to at least get a continuing resolution, or otherwise the government shuts down. And that gives a certain amount of urgency that we all witness regularly in the news to reaching some kinds of compromise for the executive branch and Congress to come together and pass things that maybe has provisions neither wants, but it sort of forces that degree of compromise. So that's another feature that matters. I just have three other points that I just want to make briefly. One is that courts, in my view, the appropriations are largely more, I think, in the political sphere than in the judicial sphere. That's been true up until now. And courts in general, when you look at the doctrines and approaches that they have, they tend to marginalize appropriations. And this is particularly true of administrative law, but it's also true in constitutional law. So if you think about constitutional law and you think about delegations, and one of the core issues with delegations is Congress is giving away all this power. Usually courts in assessing that kind of challenge don't look at what's happening on the appropriations front. Congress might be giving a broad delegation, and then what it's doing is very carefully sort of consulting and controlling through appropriations over the year. And a good example of that is Gundy, where there were actually lots of hearings over the fact that Congress wanted to be making sure that the agencies had enough money so that they could go after all of the pre-act offenders, which I'm going to assume some of you know the case and not take the time to explain it right now. But that is a good sign that Congress knew perfectly well what the Justice Department was doing, and through a measure that was enacted into law had sanctioned it. So that's marginalization. Now, sometimes that marginalization is, I think, appropriate. It reflects the fact that courts aren't the prime venue for appropriations battles. But in other cases, I think it does reflect courts failing to appreciate how important appropriations are. It also means that a lot of internal executive branch lawyering is where you get the controls and the enforcement of legal constraints on appropriations. There is a huge amount of executive branch lawyering that deals with money, government funds, the restrictions on it, adhering to it, trying to enforce it. That has always been a critical feature of our system. One of the biggest concerns about what's happening now is what it's saying about what's happening to that internal system of norm reinforcement, which is so critical to preserve the rule of law in this area. Courts can only do so much. They are not going to be involved in these debates.
Let me ask you about that last part. Let me ask you about that last part, Professor Metzger. So near and dear to my heart is how these things are actually litigated in the courts. And so you've raised, in my mind, to be a very interesting issue of what is the mechanism for how these come to courts? How are they litigated in the courts? It's one thing to say that the president has violated the law or the executive has violated the law. It's another to say who is able to enforce what the law is. And so I guess my question to you is, how do these appropriation issues, which is what you were touching on, surface in the judicial decisions, and what are the special issues facing courts in this context as they litigate these issues that are coming up?
No, it's a great question. There are some real issues here. So one of the things to think about that is, I'll just tick off a few. So sovereign immunity is one issue that comes up. You can sue for an injunction that will require an agency to take actions that will cost money. There's a case, the Bowen case, that says that. But you're also supposed to, if you're suing for money back from the government on a contract or a claim, you're supposed to do that in the Court of Claims, right? And we saw recently in the Supreme Court this issue coming up where should the jurisdiction be? Should you be suing for an injunction or not? If you don't sue for an injunction, if you can't get an injunction right away, by the time it gets litigated, the agency is dead. The organization that's getting the grant is dead because it's not the problem is it's about to go bankrupt. So there's a real tension there. When there were lawsuits over the border wall funding and the transit, there was huge questions about where's the cause of action? Can you come into court in the traditional implied equitable action for that? There's no separate right of action. Who has standing? Sometimes the interests that are being asserted, for example, this border wall is affecting environmental interests, and clear injury there for that, but that environmental interest connection to Congress's appropriations control, there's a bit of a leap there, right? So there's some real challenges, I think, on those fronts.
Does anyone else have any thoughts? Yeah, Ms. Neely, what are your thoughts, especially with regard to standing, who gets to litigate, how these things are litigated, and can you be successful, especially if it's a grantee where it's sort of we're either going to operate or not operate, we're dead or not dead if we don't get the money?
I think we're going to be finding that out very shortly. I actually have a different point, if you don't mind if I raise it, and I think it's just a very practical point that Congressman Amash, actually, you probably have the greatest insight on this. With the Impoundment Control Act, we're saying that the president has to spend appropriated funds. The president's saying, no, I don't. So let's say there's an emergency in your district. There's a flood, there's a fire. Congress appropriates funds to help recovery efforts. And the president says, I don't have to release those funds. But Congressman, I could release those funds. What can you do for me? And I think we saw that exact situation with funds for Ukraine during the first administration, Trump administration. That was actually the grounds for impeachment when President Trump was reluctant to release funds for Ukraine and had the perfect phone call with President Zelensky and kind of said, President Zelensky, what can you do for me? Can you run some investigations that might be helpful to me? What would it mean to you if the president said, what can you do for me to get the funds?
Well, I think that kind of self-dealing, if it's for a personal benefit, it's impeachable. This is the position I took, and I guess maybe one of the reasons I'm here today and not sitting in Congress. So, yeah, I think we see more of that sort of self-dealing, obviously, with the Trump administration because it's very overt. I don't know how much of it happens under other administrations because some of that is done behind the scenes. But for me, look, if someone is asking for a benefit, a personal benefit, and they're saying, we're going to release funds, if you give me that personal benefit, that's an impeachable offense. And the Trump administration seems to be willing to do this kind of thing over and over again, whether it's in the realm of appropriations or elsewhere, where they essentially hang something out there and they say, this bad thing can happen to you unless you help me out.
Professor Metzger, one of the things you sort of touched on was how things have changed over time. A lot of these laws are sort of more recent vintage or have come up post-Civil War, post-Watergate. With growing partisanship and division, where are we headed with this? Do we need new infrastructure? Are the old laws good enough? And how do those old laws fit in the current paradigm?
I'm somewhat tempted to also bump it to the congressman because I think traditionally appropriations were an area of much more bipartisan effort, an agreement. There's sort of some degree of horse trading between the two, but the appropriations committees have a reputation of having gotten along and overcome more partisan divides. There are some signs. The last study I looked at, I think, went back to the first Trump administration of more polarization in the appropriation space, and I think you're also seeing that just in general, with the very slim majorities in Congress and very different views on funding, and things like the debt ceiling and the government shutdown as a couple of points of leverage. If you care very much about a particular issue on this, we're seeing a lot of divides over appropriations and over funding the government. I do think those are issues that we have to think about. I think there are issues with the deficit that we have to think about. I don't know how you restore norm and practice that are what really keep this system working once they're destroyed. And that, to me, is the biggest challenge, because I think you can enact new statutes, you can do, well, maybe you can, do hard law measures, but the culture of law compliance, the recognition, how much you have to adhere to these constraints and how basic it is to democracy and rule of law is very hard to recreate. And that's what's really under attack.
All right, so we're going to talk about the next tool in the toolbox that Professor Chafetz mentioned, and that is the sort of the law piece, or what we'll call the reauthorization piece. We're going to hear from Professor Adler on that. He'll talk about Congress's legislative power and how the doctrine of lawmaking has exacerbated the problem of having to use old statutes in order to address new problems. Professor Adler.
Well, thank you, and let me add my thanks to the organizers. It's always great to be at this symposium. My introduction to the Federalist Society, and I guess I'm going to date myself here, was actually at the Student Symposium at Yale when I was an undergrad in 1991. And I've been hooked ever since, and I certainly hope that a lot of the students here have that sort of experience. It's this, to my mind, the Student Symposium is really the premier event, and it's the kind of the OG FedSoc event. So it's always great to be here, and it's great to be back in Ann Arbor. So in some respects, I want to talk briefly about kind of the legislative power that we're most familiar with, right? The one that's part of Schoolhouse Rock, the part of the legislature's authority to enact laws. But I think one of the ways I want us to think about it is not simply the power to enact laws, but the way that Congress structures its lawmaking, and in particular, the way Congress thinks about its own need or desire to revisit laws over time affects its ability to push back against and constrain the other branches, the executive branch in particular, and how in our current moment, when Congress seems less interested in legislating than it has been historically, this sort of consideration and focus is particularly needed. Right, so we know Congress writes laws. We know that it's a little bit more complicated than the I'm Just a Bill Schoolhouse Rock video that I showed to my leg reg students. The bicameralism and presentment process is important. It's difficult. Right? One of the most important things that people generally have to learn about the legislative process is that it's not just enough to have a majority. The majority you need in the House represents different constituencies than the majority you need in the Senate. Certainly, you need, in the normal circumstance, presidential acquiescence or agreement, unless you're going to try and override the veto. But the existence of various structures within Congress, its ability to create its own rules, which Professor Chafetz talks about in his books, also creates veto gates and other hurdles to lawmaking that require assembling coalitions that, in effect, represent supermajorities to get legislation done. And one thing that's interesting in the way that Congress has historically approached some of that lawmaking responsibility is to recreate a dynamic which Professor Metzger just talked about occurs in the appropriations process, of creating a dynamic where Congress has created very strong incentives for itself to revisit what it has done in the past. Right, so appropriations, it happens if you don't have a permanent appropriations because you got to appropriate the money the next year. And if you don't want the government to shut down, you got to appropriate the money. But with statutes, what Congress does sometimes, and there's an emphasis here on sometimes, is it not only enacts a law that tells you what you can or can't do. So maybe I'll use the Clean Water Act as an example. We had a Clean Water Act case this past week at the Supreme Court, right? You cannot discharge a pollutant into a navigable water of the United States from a point source without a permit. And that's permanent, right? Unless and until Congress revises that provision of the Clean Water Act, you cannot discharge pollution from a point source into a water of the United States without that permit. But then what Congress also does is it says, EPA, you have the authority to issue permits or to delegate authority to states to issue permits. What's interesting is that power actually Congress conceives of the way it enacted the Clean Water Act as time limited. It enacted the Clean Water Act in 1972 and said you were authorized to do this for a period of time, with the idea being that the program may work as intended, it may not work as intended. We may learn more things about the nature of water pollution and how best to control it. We may get really good at controlling one type of water pollution and realize we need to change our focus to other types of water pollution. Or we may have different views about how much we should prioritize this. So we're going to create a limit on that authorization that requires us to come back to it. And certainly in the area of environmental law, in the late 20th century, that was the norm. The Clean Water Act authorization expires and it's reauthorized, and at that moment amended in 1977, 1981, 1987. Similar story for the Clean Air Act, similar story for most of the major environmental regulatory statutes. But Congress at some point stopped doing that for a lot of statutes. And what's interesting is that if you look at the various sorts of statutes that Congress has and it reauthorizes, there are some where Congress has created structures that create the appropriations-like dynamic of where Congress has to revisit them. In a paper that Professor Walker and I did several years ago, we identified several examples of these. The Farm Bill is probably one of the easiest ones to understand. If Congress doesn't reauthorize the Farm Bill when the authorization expires, the permanent law puts in place things that were adopted in 1938 that don't make a lot of sense, and so none of the interests that have any concern about what occurs in the Farm Bill are willing to allow that to happen for a period of time, so they make sure the Farm Bill gets reauthorized. The National Defense Authorization Act is another example. And the Patriot Act is an example of something where there was limited authorization. There are others. A lot of user fee programs, right? Because the money that those user fees are time limited, and so when the authorization ends, the user fees don't get paid anymore. And so if you're the FDA or if you're the EPA with pesticide registration, you care about getting that money again. If you're a pesticide company that wants to register pesticides, you really want the EPA to have that money again, and there is political pressure to ensure that reauthorization. The problem is that in statutes that don't actually have an underlying structure that force the need to revisit it, Congress has gotten into the practice, just as it's kind of gotten into the practice of not passing lots of new legislation, it's gotten into the practice of not reauthorizing things that it doesn't really need to, right? So the Clean Water Act has not been reauthorized since 1987. The Clean Air Act has not been reauthorized since 1990. And with the exception of things that just relate to infrastructure funding, there hasn't been any action on those fronts in that time period. And so that means is that we have statutes that may have been reasonable efforts to deal with the sorts of problems they were designed to address when they were enacted and last revised, that no longer fit the world we live in, right? That's why we have all this litigation and fighting over how to use the Clean Air Act to deal with greenhouse gases, because it wasn't written for greenhouse gases. And I could bend your ear at length for why using tools that were created for traditional pollutants just simply do not work for greenhouse gases. And the Supreme Court has concurred in that. The Clean Water Act, similarly, it's not that we didn't know or think about things like non-point source pollution in the 20th century. There was no political will to focus on it, and so we have a statute that's primarily focused on point source pollution. Point source pollution is, for the most part, dealt with, and the statute doesn't get revised, and Congress doesn't reauthorize. The last thing I'll just note that's interesting is that, at least in theory, Congress is not allowed to appropriate, under its own rules, is not allowed to appropriate money for unauthorized programs. But the only way to enforce that is through Congress's own rules, or at least the only way that I'm aware of enforcing that. I don't believe there's any sort of private right of action that could be used for that. And so if Congress is going to use this power, both to keep laws up to date and avoid the problem of statutory obsolescence, but also to make sure it is in continuing dialogue with the executive branch about what sorts of power the executive branch should have in various areas, it needs to take more seriously its own responsibilities to think about how statutes are structured with regard to authorization, but also to enforce its own rules about whether or not it can appropriate money for things where authorization has expired. And I'll stop there.
So, Professor Adler, I want to pick up on that last point. Is this failed authorization problem, does that suggest that Congress should actually sunset laws and programs the way some states do that, where something automatically sunsets at 5 years and then has to be revisited? In other words, should Congress have to affirmatively approve and reenact every program for them to continue? Is that the solution?
There's a long answer. The short answer is maybe. I mean, when Professor Walker and I did our delegation and time paper, we argued, I think correctly, that there's not like a single across-the-board approach that's going to work best for every sort of program and every sort of agency, and that the idea of things expiring and stopping is certainly a very powerful incentive to force Congress to revisit things, and it is a tool to use. But in an ideal world, at least, Congress would think about what sort of program is this, what sort of time frame is this, right? There are areas of the law, there are areas of regulation where things change more quickly than others. There are areas where Congress's initial efforts to enact laws are more tentative or more experimental than others. So in the ideal world, there'd be some kind of thinking about what sort of timelines or expirations would you want in different areas. The question then becomes, if Congress is not going to do that, would some sort of across-the-board sunset be better than nothing? And I'm open to that. I think the state experience is less conclusive in that regard than I think we would like. That is to say, there are states that have used sunsets effectively, but there are certain sorts of programs that might not need that sort of medicine to the same degree.
Professor Chafetz, my senator proposed at one point something like a 5-year sunsetting of just about everything in order to fix this. I know a big premise of your book is that the legislative function has atrophied, and so we should try to use these other powers, these other soft and hard tools that are out there. What do we do with this problem in an atrophied legislative framework? How does this all work together?
Right. So I agree with Professor Adler. This is a problem, right? That Congress is not as regularly revising statutes. I think that is a serious issue. I mean, I think the most likely explanation for it, right, is the rise of partisan polarization. That it's simply significantly harder to find cross-partisan agreement on reauthorizing various statutes. And for that reason, I think a sort of 5-year cutoff would potentially be disastrous. I think the state experience is probably not terribly illustrative here because there are very few states that tend to have divided government, right? There are some, but states are much more frequently have unified government than the federal government does. And state legislators traditionally, and even still today, tend to be somewhat more interested in working across partisan lines, even where there is divided government. So things that are feasible at the state level are not, under current conditions, terribly feasible at the federal level. So for that reason, I think sort of these automatic cutoffs across the board would be a disaster. We'd wind up with, the FAA would disappear tomorrow, and I want to fly home tomorrow. So I think that can't be the right answer, but I do absolutely think we would be a lot better off if Congress returned to these statutes a lot more frequently, and it's worth thinking through some of the kind of sort of smaller bore suggestions that Professor Adler and Professor Walker have talked about.
Ms. Neely, you've spent a ton of time in Congress. What do you think the solution is? If it's not a 5-year sunset, if that is catastrophic, what is the way to help us deal with this old statute, new problem issue where you have statutes that either haven't been reauthorized in a long time and sort of don't fit modern problems, or are just sort of going along and being appropriated without having been revisited, or are sunsetting and you're in this sort of dead period of like, we have to do something, but nothing can be done? What do we do with this?
I think that is a challenge, and actually one other problem that just kind of occurred to me with the 5-year sunset is that if a program like the FAA just went away tomorrow, do you think that the executive branch would actually say, okay, FAA is gone, we're grounding all planes, or do you think the executive branch would say, okay, this is an emergency, I'm going to find some sort of emergency power, or this is insane, we're going to keep this running, and is that going to contribute to the imperial executive? I think probably the latter, because everyone wants to fly home tomorrow. It's really cold here. So I love Michigan, just kidding. So I think that, and I also will say that with a 5-year sunset or a 7-year sunset, I spent a good 3 years negotiating a bill to deal with a program that was going to expire after 7 years that Senator Portman had gotten enacted. And during those 3 years, the people running the program were kind of like, well, you know, it's expiring in 3 years and you don't know if it's going to get reauthorized. So they were really reluctant to do things with it and to exercise that authority. So I do think that a 5 or 6 or 7-year sunset for every single statute is probably not a workable solution. What the solution is, I don't know. One potential idea would be to think about what the rules are in the Senate and the House about amendments. One thing that makes members reluctant to bring bills to the floor is the fact that amendments will come up. There will be tough votes, and they could be amendments based on a lot of different topics. And if you can limit what those topics that could arise are when you're renegotiating legislation, that might be one way to approach part of the problem.
Congressman, do you think something like the Budget Control Act, where there's a strict process for how to authorize these things, no filibuster, some sort of process for reauthorization could streamline and help this problem, or is it unfixable?
I don't think it's unfixable, but I do think that if you don't address the institutional problems, the institutional dysfunction, you can't address the problems with sunsets. I mean, the point is right that if you had something that was critical that were to sunset, you're more likely to get a president, especially maybe someone like President Trump, who'd say, well, I'm just going to do what I want. I don't care that they didn't reauthorize this. I would like to see sunsets for new legislation, things that are new programs that have come up. I mean, you know, some of these old programs, maybe they've been going on for years. A sunset might not work the same way, but something new, okay, you're trying it out, it's like a test run. So I would like to see that, but, you know, I'll talk about this more in my portion of the presentation today. I think if you don't fix the institutional problems, the sunset issue is like a symptom of the bigger problem.
I suspect that's true of a lot of what we're talking about today. But with that, we're going to turn to the third tool in the toolbox, and that is investigations. And for that, we're going to hear from, as I said, Ms. Neely, who really spent the bulk of her career working in the halls of Congress. She's going to discuss Congress's authority to investigate. So, Ms. Neely?
Thank you. And I'll just pause and really thank the Federalist Society for hosting this convention, for Michigan for putting this on, and Trey, thank you for organizing the panel. You've done a brilliant job, and it's really, really great to be here with y'all. So, like Professor Metzger, I will spend a little bit of time talking about the norms or the way the world usually works, so you have an idea of what these tools are that are in Congress's toolkit. And we'll talk about where Congress gets the authority to investigate, what the practical tools they actually have are, and then I'll touch on what's going on today, and we can get into that in the Q&A a little more too. So in terms of the authorities, the textualists among you might be a little bit concerned. Nowhere does Article 1 or anywhere in the Constitution say anything about Congress has the power to investigate. But I think that the originalists among you can take a little heart here. At the Federal Convention, James Madison reported that George Mason commented that members of Congress are not only legislators, but they possess inquisitorial powers. And they were looking back to the examples of the House of Commons in Great Britain. And it was understood that at the time of the founding, that the investigative power was inherent in the legislative power. Congress just can't write good laws without having a good understanding of the facts. And Congress can't be assured of getting those good facts unless it has the ability to compel reluctant witnesses to come forward and provide that information. And the Supreme Court has acknowledged that authority repeatedly, as has the DOJ Office of Legal Counsel. Congress's investigative authority, however, is not unlimited, and we've been seeing a lot of recent case law here. It's a really fascinating, developing area of the law for anyone looking for a note topic for a journal. The development of the law in congressional investigations is a really great area. But for our purposes today, suffice it to say that Congress can't go on a fishing expedition, and unlike a grand jury, it is not entitled to, quote unquote, every scrap of paper. And crucially, Congress must have a legislative purpose underpinning its investigations. And that begs the question, can Congress have other purposes for its investigations? Yes, absolutely. We see that all the time. They investigate to advance a political agenda, to bolster the president's agenda. They investigate to expose wrongdoing. They might be trying to support a parochial cause, but they do have to articulate at least some legislative purpose. So that's the power to investigate. And then how does it practically go about actually conducting these investigations? We see it in the headlines all the time that Congress holds hearings. That's sort of the culmination of an investigation. But the two chambers, actually, they have the authority to investigate, and they delegate that to the committees. And each committee has its own specific rules for conducting investigations. And it's very important if you're representing someone before Congress to know what that committee's rules are. But generally speaking, most of the committees will gather information initially by asking parties for a briefing or looking at publicly available information. And then it may send a letter request to the target of the investigation, whether it's a private party or a public institution. And that letter may be just from the chairman of the committee. It may be on behalf of multiple members of the committee. And then I think most powerfully, it would come from the chairman and the ranking minority member, because a target knows they're in trouble when they're getting heat from both parties. If a party does not produce the information, Congress can, as I mentioned, subpoena the information from the party and enforce that subpoena. They can also conduct depositions, which are under oath, or less formally, they can do a voluntary transcribed interview. And then, of course, you see the committee hearings, as I mentioned. And then when it comes to oversight of the executive branch, you will generally see more fireworks when at least one chamber of Congress is controlled by the opposing party to the president. But in that case, you can see the investigations become much more political in nature. Think Hunter Biden laptop, or the alleged collusion between the Biden administration and social media companies to restrict conservative speech over the last few years. But when Congress is doing its job right, oversight should not stop at the party line. You will see over the next 20 months lots fewer investigations, I think, about scandals, ginned up or real amongst the administration. That will come back when Democrats take control of a chamber. But I think you will see a lot of oversight of kind of the workaday functions of the federal government. And this will be an interesting form of oversight because it will be the Congress sort of participating with the administration in the oversight of its own operations. And we've already seen this happening. The House Committee on Oversight and Government Reform, they formed the DOJ subcommittee, and their whole purpose is to expose waste in the federal government. And I think that you will see the administration really cooperating with this. And a lot of administrations, you wouldn't see that. And there probably will be some political overlays to some of this. But they can request documents from federal agencies. They can compel documents from federal contractors and really highlight some of the work that the DOJ is doing. And it's to DOJ's, the Department of Government Efficiency's benefit, I think, to have Congress doing this because they will need legislation in order to actually effectuate some of what their goals are. That's maybe a somewhat rosy view of Congress's role in this current dynamic. But I do think that as politics evolve, we might see Congress taking a little bit more of an affirmative action to hold the administration itself accountable for various issues. We've seen recently people like Senate Budget Committee Chairman Lindsey Graham. He's trying to find ways to codify some of DOJ's work, and he's admittedly said and acknowledged that they need to fix some of the problems that maybe DOJ has introduced, and effectively saying that Congress needs to take back a little bit of control here. And then I think we are starting to see President Trump's approval ratings decline a little bit, and I think that members of Congress, if that continues, Republican members of Congress might see oversight as an opportunity to express their independence and to try to win back some swing voters. But that only is if President Trump's approval ratings decline and they're experiencing some concern back in their home districts. And how they will effectuate that oversight of an unwilling executive is a topic for further conversation. But I will pass it back to our moderator.
Well, let's go to that last point. So when both chambers, as we have now, are held by the same party as the president, what does that congressional oversight look like, and what should it look like? So in other words, what is it going to look like? Do you predict now, or what's going on right now? And what should happen in a properly functioning Congress?
Well, the original vision was that there was a real concern about factions, and we, I think, are experiencing now what factions really look like. But the idea was that there would be institutional loyalty to the Congress, loyalty to the executive branch, and that Congress would exercise its oversight authorities based on that institutional loyalty. And we're not seeing that as much right now. We're seeing loyalty toward party. So I personally am a big believer in that Republicans should do oversight of Republican administrations and Democrats should do it of Democratic administrations. I think it's important to hold our government accountable. What will it look like if they decide that they need to get information that the administration does not want to produce? It's interesting, because one way that they would enforce a subpoena, including against a private party or a government entity, is to refer the subpoena or a contempt citation over to the Department of Justice. The Department of Justice is not going to be very inclined to bring a case against its own administration. And even though the statute says that the Department of Justice actually has to bring the case, we've seen Department of Justice decline to do that any number of times. So they have to look for, I think, softer power ways of enforcing or persuading the administration to cooperate. What I saw during the first Trump administration was Senator Portman, as chairman of the Permanent Subcommittee on Investigations and chairman of the Homeland Security Committee, or ranking member of the Homeland Security Committee, was willing to push the administration to get information. And a lot of that happens behind closed doors. The administration does not necessarily want to come up before Congress and expose problems. So some of that you will see happen, well, you won't see it. It will be behind closed doors. So they will come to you and say, okay, we don't want to have to testify about this. Please don't send us the subpoena. Let's talk about how we can compromise. And there's a lot of back and forth horse trading on that.
Professor Chafetz, again, you've written a lot about the soft power part of this. How does this investigation part come within the soft power, especially when you have this sort of monolith party of Congress and the president and both houses being of the same party? How does that work in the context of Congress trying to reassert itself?
Right. Well, I mean, I absolutely agree. We're going to see less investigation of the administration, at least of the White House, in this Congress, precisely because of unified partisan control. The one thing I would just add to what you said is that, yes. So from the Bush administration, the Obama administration, and the first Trump administration, there were administration officials held in contempt of Congress in all three of those administrations. All three times the Department of Justice refused to prosecute. All three times the House of Representatives, it was in the House each time. All three times the House of Representatives responded by filing a suit in federal district court in the District of Columbia, and this is a chumps game for the House every time, because what happens is the House might actually at the end of the day get favorable rulings. In fact, for the most part, it has gotten favorable rulings. The thing is, the favorable rulings on the contempt in the Bush administration came during the Obama administration. The favorable rulings on contempt during the Obama administration came during the Trump administration, and the favorable rulings on the Trump administration contempt came during the Biden administration. So not only that the Congress that was trying to do oversight was out of office, but the administration they were trying to oversee was out of office by the time they won these cases. Right? So going to court is just a chumps game for Congress in these cases, and so they have to use some other kind of power, right? I think the best available option, and this goes back to something Professor Metzger talked about, right? The best available option is the power of the purse, right? The best available option is to say, you know what, if the White House counsel's office isn't gonna come testify before us, then we're not gonna pay for a White House counsel's office, right? And that is something that Congress could easily do, but has chosen not to, right? Across these various administrations. But at the end of the day, it's got to find, if it truly wants to get information from an unwilling administration, it's got to find some mechanism that it can tug on. Potentially holding hearings and embarrassing the administration is one way to do it. And I've talked to staffers at various points about ways to sort of structure the theatricality of those hearings when witnesses refuse to show up. Things like, having an empty chair with their name in front of it, asking questions of the empty chair. There are ways that you can dramatize, right, refusal to play along. But Congress needs to start thinking more creatively about them.
Whistleblowers are another
Yeah,
great source of information, and we might be seeing more of that going forward.
Professor Metzger, Professor Chafetz mentioned the appropriations power as a mechanism to sort of spur on oversight and investigations. What do you think about that tool, especially, again, when you have a unified party between Congress and the president?
I mean, I think the partisan valence means that when you have a unified party, you're not going to see these tools being used to enforce oversight, and that's part of the problem. I think how much goes on, even cross-party, even when you have divided government, how much goes on in terms of negotiations behind the scenes is an important point to emphasize, because I think that we definitely do see that. Part of the problem with appropriations could definitely serve that purpose, but often appropriations end up being very high-stakes battles, and no one issue is it becomes critical. The only thing that I wanted to just put on the table is one other thing that we have seen, and this crosses both Democratic and Republican administrations, are new sort of assertions of immunity from the process that we get from the executive branch. There are longstanding claims of executive privilege in particular instances, but we start to see much more assertions of testimonial immunity where you don't even have to show up at all, making the threat to the power of oversight that much more stark, leading to the empty chair.
So our final panelist, Justin Amash, spent a decade on the ground dealing with these congressional tools that we've spent the last hour talking about. He will explain how the centralization of power in the House Speaker and the Senate Majority Leader undermines the separation of powers, and how the conventional tools that we've been discussing lose their strength when leadership consolidates. Congressman.
Thanks, Judge. Thank you, Judge. And I want to say thank you to the Federalist Society. I was a member of the Michigan Law Federalist Society, and I sat in this room and took classes, and so I'm really happy to be here. And I especially appreciate the ironic theme for this year's symposium. So I could talk for hours about what's wrong with Congress. It's really one of my favorite topics. I held town halls many times, spoke for hours on end. I'm going to try to actually read from some prepared remarks so that I can get through this in a very straightforward way without getting sidetracked. And then we'll have some discussion, and I think that's where more of the interesting conversation will happen. So we've heard today about the ways Congress can check the president: authorizations, appropriations, investigations, and more. These are vital tools rooted in the Constitution's design to ensure no single branch dominates our government. But there's a problem too few notice. The centralization of power in the House Speaker and Senate Majority Leader renders those checks ineffective. This isn't a minor glitch. It's a fundamental threat to the separation of powers that keeps our republic balanced. Let me explain why in 3 steps: how leadership has overtaken Congress, why this cripples its ability to act, and how it shifts power to the executive branch. Article 1 vests all legislative powers in Congress, the House and Senate collectively, not a handful of leaders. The Speaker's role was to facilitate debate, not dictate outcomes. That's not our reality anymore. Leadership rams spending bills through with little debate, sometimes relying on continuing resolutions to dodge real fiscal decisions, avoiding the tough votes constituents expect. Amendments, once a cornerstone of legislative input, are now rare. When Nancy Pelosi was Speaker, she blocked them from being offered from the floor for 4 years. And to put that in context for you, up until Speaker Ryan's tenure, there had never been an entire term of Congress where amendments were not allowed to be offered from the floor at all. So under Speaker Ryan's tenure, it was the first 2-year term we ever had where not a single amendment was allowed to be offered from the floor. Now, that doesn't mean there wasn't an amendment voted on the floor. It just meant that a member of Congress could not come to the floor, for example, on an appropriations measure, through an open rule, meaning where the member can just offer an amendment and it will be voted on. That didn't happen one time under Speaker Ryan during his last term, and it didn't happen the next 2 terms under Nancy Pelosi. And then under Kevin McCarthy, it only happened 1 time, I believe. And I don't think it's happened at all under Mike Johnson. So to show you how dysfunctional this is, we had since the beginning of Congress, we'd never had any terms where amendments could not be offered. And now we've had, over the past 7, 8 years, a consistent system of denying members of Congress the ability to speak out on the floor through amendments. It's not just a quirk, it's a deliberate chokehold on the rank and file, ensuring only leadership's priorities see daylight. In the Senate, the majority leader sets the agenda, sidelining open deliberation, deciding what gets a vote and what dies in silence. This centralization isn't about efficiency, it's about control. It turns a body of 535 representatives into a machine run by a few, overriding the will of hundreds. Congress stops functioning as the framers intended when power consolidates like this. It's no longer a legislature, it's a fiefdom. Centralization doesn't just grab power, it hollows out Congress's ability to check the executive. Oversight via investigations and control through appropriations wither under leadership's dominance. The Rules Committee serves the Speaker, not the body. The Oversight Committee bends the same will, choking scrutiny. And I served on the Oversight Committee, and to give you some context there, when I served on the Oversight Committee, they would present us the script that we were to read at the hearings. So when you watch these hearings on TV and you think these members of Congress are just, speaking off the cuff, or maybe they're working with their staff on writing some questions, what happens a lot of times, especially in the very publicized events, is the Speaker, working with the chairman of the committee, will draft the entire script for the meeting. And as an example, one time I refused to read the script they wanted to give me, and I was actually the second highest ranking member on the Oversight Committee. And they insisted that I then go like 7th or 8th in line rather than go second, even though I was the second highest ranking member. So I refused to read their script. They pushed me to the back so that I wouldn't be during, I guess, the primetime viewing segment. But this is a consistent problem where things come from the top. It's not really as organic as you might think. And the reason it happens is also because under this system, members of Congress end up knowing very little. So if not for the fact that they were given a script, they actually might not know anything about the subject. So sometimes when you're watching these members of Congress speak, and it seems like they don't know anything about the topic, it's because they don't know anything about the topic. Which is why you'll often hear the question they ask the witness will happen at the very end, because the leadership is trying to protect them from a back and forth. They don't want a back and forth. They just want to berate the witness and then move on to the next person. So under this system, dissenters lose influence, committee assignments, chairmanships, and campaign support vanish, leaving members nearly powerless. Senators face the same. The majority leader dictates terms, and choices shrink to fit the leadership's agenda. Recent appropriations bills show it. No debate, no challenge, just leadership stamp. Hundreds of pages dropped hours before a vote, daring anyone to object. The last debt ceiling hike, a backroom deal. No hearings. Centralization doesn't even bring the efficiency its defenders promise. It slows legislation as leaders scramble to guess what the body might tolerate, weakens Congress by sidelining its members, and silences the broader input that keeps it accountable. Centralization doesn't stop at paralyzing Congress. It hands the president an outsized advantage. Instead of engaging 535 lawmakers, each accountable to their constituents, the executive negotiates with a few leaders, the Speaker, Majority Leader, and often the Senate Minority Leader. Picture a president dialing up, Mike, John, let's settle this. Debt limits, tax policies, even military actions are resolved in these narrow talks, bypassing the broader House and Senate. The executive doesn't have to wrangle a diverse Congress. He just needs a handshake from a couple of power brokers. If every presidential request hit a wall of leaders saying, good luck getting that through the whole body, the executive would falter, and Congress would stand stronger. Instead, he has to convince just a few leaders, giving him considerable leverage in any exchange. Centralization hands the executive an edge. It leaves the judiciary overburdened and the system askew, a quiet handover of authority we're all paying for. The tools highlighted today, authorizations, appropriations, investigations, are essential, but they're meaningless without a Congress free to use them. Centralization in the Speaker and Majority Leader doesn't just limit debate, it undermines the separation of powers at its core, tilting our government away from the people's voice. Both chambers must reclaim their roles, open processes where every member can weigh in, robust committee work that digs into policy, and a structure that empowers the rank and file, not just a select few at the top. Imagine a House where the Rules Committee answers to the body, not the Speaker, or a Senate where the Majority Leader can't kill a bill single-handedly. This isn't an abstract concern, it's a practical necessity to check the executive and represent the people. We can't keep pretending 2 leaders equals 535 voices. We must rebuild a Congress that reflects the framers' vision, embraces its own power, and checks the executive as intended. It's time to stop ceding ground and start fighting for the legislature our founders designed. Thank you.
Thank you, Congressman. In doing a little bit of research here, I noticed that you actually offered yourself up as a speaker at one point.
Right.
I think as an outside speaker, but as speaker. Speaker Amash, what specific rule changes would you prioritize to fix the problems that are there? And then I'm going to open that up to everyone else to see what suggestions they have, and then we're going to turn it over for questions from everyone here.
So I have offered myself up as speaker. There weren't enough takers. But it's not as far-fetched as people might think. I think there is the potential for someone to bridge the gap between the parties now, and maybe it's not a person from outside of Congress, but I think there is potential for that. I think you have to ensure that the rules are followed first and foremost. So every week I served in Congress, every single week, the rules were waived or suspended. Every single week. So at the beginning of the term, we set the rules for the body. And then every week we waive them or suspend them. Sometimes they'd have a rule that required 2/3 majority, and then they'd waive it or suspend it with a simple majority. So this happened time again. You have to follow the rules. But I think you have to make Congress more transparent. You have to set put some principles in place, some rules within the body that are followed and followed consistently. For example, I wouldn't allow a vote to take place until several days after the very last change in the legislation. If a comma's changed, if a period's changed, you got to have, say, 3 days before you vote on that thing. That's important because things might come to the floor. Sometimes what they'll say, they have these 3-day rules or a 72-hour rule or whatever it might be. And they'll put a shell bill on the floor. It could be a bill for a completely different subject. They'll shove in a manager's amendment from the leadership team, and they'll say, oh, well, this bill's been on the floor for a long time. But you just amended it 3 minutes ago, and now we have to vote on it. Okay, but it's been available for 3 days. So people will say things like that, and it's disingenuous. So we have to have a rule where you can't change things like in that fashion and then have a vote immediately. I think you have to make the legislation more transparent for everyone, and this would be helpful to the public, help people hold Congress accountable. Right now, the way most legislation is written, especially longer legislation, is a bunch of cross-references. So when you hear that a bill is 3,000 pages or 5,000 pages, it's actually much longer because it's referencing a whole bunch of other acts. So who knows how many pages it is? And every single congressperson who's dealing with this, if they actually care about the issue, as I did, has to have their staff then piece it together so that you can actually read it in some kind of coherent fashion. Otherwise, it's just nonsense. You just be flipping pages back and forth. So you have to have a system where you can read the legislation.
All right, I want to do lightning round. You're king of the world or king of the United States. You get one fix for the problems that you've identified. What are they? I'll start, Ms. Neely, I'll start down by you.
Oh, that is not fair at all.
Sorry.
Well, I don't know that this solves any of the problems, but it is something that I've been advocating for some time, and Congress has been trying to fix it a little bit. But Congress, in terms of its relative power associated with the executive branch, underpays its staff and is not able to have long tenured staff because the staff just don't make enough money to be able to stay. I do think that to acquire more expertise on Capitol Hill, they do need to hire more professional staff, and they need to pay them commensurately.
Professor Metzger?
I'm not sure I've got a fix to the appropriations and budget problems. I wish I did. But I do have a question for the congressman at some point, once we're done with our lightning round.
Professor Chafetz? You wrote a whole book.
Yeah, and no firm solutions. I do absolutely agree that staff are way underpaid. There are way too few of them, way too little continuing expertise. Staff are, the total staffing numbers in Congress are lower than they were in the late 1970s. Staff pay in real dollars is lower than it was in the 1980s, right? This is awful, right? This means you have people sticking around for a year or two in these positions that are tremendously important. And then you contrast that with the executive branch, right, where people are able to make sort of long careers out of it. It's not surprising then that you have these sort of informational and expertise asymmetries. So I won't fix everything or even a huge part of everything, but I fully sort of co-sign that.
Professor Adler?
First, I was hoping Professor Chafetz was going to say inherent contempt, and someone should ask him about that. I think one thing that would be helpful is to prevent leadership from being able to preclude points of order. So, for example, both the House and Senate rules have a point of order that can to bar the appropriation of funds for unauthorized programs. Those point of orders don't get raised. I think in the House, at least, that's because of closed rules. But a rule change that prevents making a point of order from being out of order, so at the very least the majority has to vote to make it go away, I think would do a lot to at least make it transparent that we're appropriating money for unauthorized programs. Would it solve everything? Of course not, but I think it'd be a good step.
All right, let me open up to the floor, and then we're going to have Professor Metzger's question also. So I saw your hand first. If you can just tell us your name or what school you're from. So committee chair appointments, how they're done, would that be a fix to some of the problems you identified, Congressman?
Yeah, I think that would be helpful, and that's something I supported. You have these committee chairs that are, again, top down from the leadership, and increasingly I think people don't recognize this, that chairmen are just beholden to the leaders. You know, it used to be the case that a chairman might actually present something that is very different from what the speaker or the Senate Majority Leader wanted. It's very rare these days that such a thing happens. If it happens, it's newsworthy. It doesn't happen very often.
Professor Chafetz.
So I think that's. So I think a little bit of historical context here might be a little bit helpful. So, right, so the House was as centralized from about 1885 to 1910 as it is today. Incredibly centralized. So Speaker Cannon was known as Czar Cannon, was regarded by many as more powerful than the president. And then in 1910, you get this sort of cross-partisan alignment that takes him down. And actually, one of the things that comes out of that is that the Rules Committee afterwards is taken away from the Speaker and is elected by the floor. But also that committee chairmanships then move to a seniority system rather than a sort of centralized appointment system. The result of that was not actually a Congress that was sort of more representative of its median member. The result of that was these fiefdoms in various committees, right? So certain sort of interest groups wound up controlling certain committees. Most infamously, the Southern Democrats wound up in control of the judiciary committees, which gave them strangleholds on civil rights legislation, right? So I think While I very much agree with Congressman Amash's call for taking some power away from the leadership, you've got to be careful how you do it, because it doesn't necessarily create a body that is sort of more representative to its median member.
Yes, I saw you right there. Yeah, if you tell me, yeah, you. Sorry. Tell me your name and what school you're from.
Hi, my name is Ava. I'm a 2L at Duke. One congressional kind of tool that I've been thinking about lately as it relates to separation of powers is Congress's ability to draft statutes in terms of judicial review being placed on agency actions. And I was thinking, this could go two ways, right? If Congress doesn't want the power to make a lot of decisions, it could sort of take the courts out of the judicial review process and, prevent them from reviewing agency action, or it could go the other way and assert itself and say, we want to delegate all of this power and we want to remove the court's ability to kind of review these sorts of things. So I'm wondering if you see from both a practical perspective and theoretical perspective how the tool of establishing standards of judicial review and statutes works for Congress, and if that's something that it's thinking about at all, or if that's something that might come into play as it's dealing with the court's anti-administrative turn and also, asserting itself potentially.
I'll start with Professor Adler on that one, and then open it up to anyone else.
So it's certainly important. We don't know how far Congress could go in terms of precluding judicial review, but authorizing judicial review certainly helps discipline the executive branch. And I think related to that, and I think it's important to understand, is the creation of citizen supervisions that allow for individuals to not merely sue the agency, but also to directly sue regulated parties. That really expanded initially with environmental laws as well as with some other laws in the 1970s and 80s, in part because Congress didn't think the executive branch was going to enforce those laws as aggressively as Congress wanted to. So, for example, under the Clean Air Act, if you're operating without a permit, you don't merely have to worry about EPA or the Justice Department enforcing against you. If they fail to, a citizen suits can file, and there's nothing, under current law at least, nothing the executive branch can do in terms of enforcement discretion to prevent that suit from being filed. Clean Water Act has an even more aggressive provision, which doesn't even allow the federal government to take over the suit and enforce the provision less stringently than the citizen suit would have. So it's certainly true that Congress can do more in that regard. Just be aware, there's a serious argument that not one that I subscribe to, but there is a serious argument that at some point some of these citizen supervisions may impede upon conceptions of Article 2 and the president's authority to see that the laws are faithfully executed, and that is an argument we are increasingly seeing raised in courts.
Professor Metzger.
Yeah, so one thing I was just going to mention quickly is that we are seeing some pullback of congressionally created interests as a basis for standing, so that's one thing that's been happening. But the other thing is, one area where Congress could get involved, particularly with judicial review, would be in terms of the remedy side. We've been having very big debates about national injunctions, the extent to which you want courts to be able to enjoin a program nationwide or vacate a rule in the kind of nationwide way. That's an area where it would be very helpful to have Congress stepping in, I think, to address.
Saw your hand right there. If you just help, yes. Your name and what school you're from?
Hi, I'm Luke. I'm from Penn State Law. Thank you so much for this. So here is the issue I would like. This goes out to primarily Professor Metzger, but maybe all of you. My understanding is that impoundment was thought to be constitutional before President Nixon, and then Congress tried to take it away, and obviously this is an issue again under President Trump. Is impoundment just in and of itself constitutional? Is that something the president has the authority to do lawfully or not?
And the only thing I would add to that I'd like for you to address too is how this overlays with executive discretion with prosecution. In other words, the analogy is often made that something is against the law, the executive needs to take care, but no one thinks that the executive has to enforce every law at every second, at every time. There's some discretion built in. This came up a lot during some of the DACA litigation. How does this all play together in concept of impoundment?
Sure, happy to. And actually, that's a very helpful riff on your question, because there is a long historical practice of presidents sometimes not spending the full amount that had been appropriated. But if you look at the underlying statutes, they allowed the president to do that. The presumption was in terms of, they were either expressly, or the presumption was in terms of them having discretion. And so you really can't separate out the fact that that was the statutory basis from the acceptance of that. And in fact, as I tried to convey, there's actually both strong constitutional basis and a lot of practice of this being a very core congressional power, so that if Congress said no, it would be different. I think it's different than prosecution, in that I think prosecution investigation, we tend to put more from the outset as a core executive power. And appropriations and funding are not. Charles Black famously said that you could just cut off funding for the executive branch, because this is so much of a congressional power and not something the executive branch has any inherent power to. And with that different baseline, it's not really the best analogy to think of it in terms of prosecution investigation.
Professor Chafetz.
Yeah, so just on the sort of historical practice of it, there are sort of impoundments that occur throughout the 19th century, not the 1803 Jefferson one that people sometimes talk about. If you actually look at that statute, that says up to $50,000 to purchase up to 15 gunboats. So that's not an impoundment, that's just following the statute. There are a few impoundments in the 19th century that people who work on this tend to call routine impoundments, and those are almost exclusively cases where Congress has specified what needs to be bought, and it just turns out you could buy that same thing for a little bit less money. And you get an, I think, 1898 Attorney General opinion from Judson Harmon, Grover Cleveland's Attorney General, saying, again, as long as we're following Congress's instructions, if we can save money, that's fine. You don't get what are called policy impoundments until after World War II. You get a little bit from FDR, and then you get a little bit more from Truman, but really they're very much sort of at the margins, and Congress pushes back against them. And then Nixon begins using them really as an instrument of policy. And as soon as Nixon begins using them as an instrument of policy, you get pushback from both of the other branches. So you get pushback from the Supreme Court in Train versus United States, and you get the Impoundment Control Act of 1974. And what I'll just say is, right, the debate isn't about violating the Impoundment Control Act. The Impoundment Control Act, as Professor Metzger pointed out, is permissive. It tells the president, under certain situations, you can rescind funds, right, with Congress's approval, or you can delay dispersing those funds, right? What the Impoundment Control Act is very clear on is that policy impoundments are not acceptable, and that is as a matter of underlying constitutional and statutory law, right? Because if the appropriation is phrased in mandatory terms, then impoundment is simply saying, I'm not going to follow the terms of the appropriation, right? And that is basically claiming a dispensing power on the part of the president.
Professor Metzger.
Just one thing we haven't mentioned. So Congress appropriates funds, and then the executive branch obligates the funds. One of the things that's happening right now is that it's not just appropriated funds that are being taken away and not spent. It is obligated funds, so funds for which there is a legal obligation on the executive branch. The executive branch has already committed the funds, and those are not being spent. So that's an even further step, more extreme, and I don't think we've seen obligated funds not be spent this way.
Yeah, on this side. So, sir, in the back over there. Yeah, the beard. It's you.
All right, thank you all for being here today. My name is CJ. I'm a 1L at George Mason University's Antonin Scalia Law School. So we've got 50 state governments across the country, obviously, that more or less act as microcosms of many of the issues that we see at the national level. And the panel talked a little bit about the sunshine provisions that a lot of state legislatures enact along with legislation. But are there any other specific practices or tools implied by state legislatures that Congress can look to reclaim some of its proper institutional duties and remedy some of the issues that we've talked about?
Congressman, I'll start with you with that question, and then Ms. Neely, I'll bring you into it.
Well, I brought it up before, which is legislation should be easier to read. And I think we shouldn't be dismissive of this point. I think it's often, just, well, okay, it's legislation and they have staff who can read this. Most members of Congress have a relatively small group of people working in their office. You might have 2-3 legislative staff, and you are getting a whole bunch of stuff sent at you. And these might be thousands of pages. And then it's also put into code because it's all cross-references. And I don't think the average person recognizes how complicated that can be for a staff that's on in a very highly pressured, time-sensitive situation trying to figure out what's going on. So if you can just make it easier to read, that would be helpful. The state of Michigan, for example, when I served in the state legislature before I served in Congress, when you get legislation here, it is just like a track changes document. You can see things crossed out, inserted. It's very easy to read. Now, the legislation is also shorter than typical congressional legislation, but we could vastly improve federal legislation by making it track changes style.
Yeah, Florida, I know, has a 72-hour cool-down period, especially for the end-of-the-year appropriation, which is the biggest legislation. I know other states have similar both statutory and constitutional requirements. Ms. Neely, what are your thoughts on reform?
2 words, balanced budget. Maybe a third requirement.
Florida has that too.
Yeah. Thank you. Yeah, I just, a very, very quick Google. In 2021, according to the Tax Policy Center, 45 states required the governor to submit a balanced budget to the legislature. 44 states required the legislature to pass a balanced budget. I think we could learn a lot from that.
We're going to end there. We like to end on time and start on time. Really, give this panel a hand. This was just so informative.
A couple announcements going into break. We'll be back in here promptly at 11 to start our next panel. If you need a banquet ticket still, there have been a few people who have dropped off the wait list, and you can go out to the registration table and purchase one if you need. It's going to be a great event this evening at the Big House. Even if you're not a football fan, which you should be, it's still a great venue, still will be a lot of fun. So if you're still looking for one of those, you can purchase it. If you are a chapter president, there will be a photo by the marquee letters out front of this room directly during the break. So those two things, and being here back at 11 for our next panel. Thank you.